Good afternoon to everybody logging into the FTB webinar on recent cases on protestor and gypsy and traveller injunctions. Just going to wait a few moments for everybody to join, and then we'll get cracking in a couple of minutes. As I said a moment ago, we're just waiting for a few more to log on before we get started on the webinar. Just going to allow a couple of moments more for people to come on. Right, good afternoon. I think it's probably time to get started. Welcome everybody to this FTB webinar on a couple of very important recent cases on injunctions, gypsy and traveller injunctions, and protestor injunctions. I'm Andrew Fraser-Urquhart KC. I'm joined this afternoon by Michael Fry, Michael Feeney, and Charles Forrest. And we're going to be talking to you about the two important and very recent new cases. First of all, clearly in the Supreme Court, the case which is now known as Wolverhampton City Council and London Gypsy and Travellers. It was known to those who follow the litigation in the Court of Appeal as the Barking and Dagenham case. Judgment handed down on that on Wednesday. And we're also going to be talking about the case of Kirin and National Highways, which was a committal case, again handed down at the very end of October. Wolverhampton, as I'm still learning to call it, was a gypsy and traveller case. Kirin is a case involving committal of protesters arising out of the National Highways protests. Just to tell you, as it were, who we all are and how we fit into the scheme, Michael Fry and Michael Feeney have acted for National Highways Limited in the Kirin case, and Michael Fry's involvement goes back a good deal further, to right to the beginning of when National Highways were securing injunctions against Insulate Britain and thereafter Just Stop Oil and other protesters. Michael also appeared in the Supreme Court in the Wolverhampton City Council case, so he's as well versed as anyone to speak on these issues. Myself and Charles Forrest acted for Transport for London in securing injunctions against Insulate Britain and Just Stop Oil. So we're, in some ways, we're two teams, two sides of the same coin. The format of today is going to be as follows. Charles is going to take us through what's been decided in the Wolverhampton City case. And then the two Michaels are going to take us through the Kirin case. And when we've done that, I'm going to offer a few words to try and point out some more general importance points from these cases. After that, we will take questions. We're very keen to have a decent discussion about some of the issues that come out. So do please share us your questions so that we can lead off that discussion. You can post them on the Q&A function, which is enabled at the bottom of your screens. And we hope that we'll spend about an hour discussing these two cases. So without further ado, I'll introduce Charles Forrest, who's going to tell us what the Supreme Court has decided in Wolverhampton City Council on the basis of the appeals from the cases we all used to know as Barking and Dagenham. Charles, good morning. Good afternoon, even.
Good afternoon. Thank you, Andrew. So I'm going to talk about the Wolverhampton case handed down on Wednesday. It was actually heard back in February, and the reason for the delay, I think, was explained when we saw the judgment. It's 77 pages and takes plenty of things from first principles. So I'm just going to give sort of a nuts and bolts summary, but I think there's no replacement for reading it yourself when you get the time, because there's a lot of nuance, there's a lot of stuff there which can't be covered in the 15 or so minutes, 10-15 minutes or so that I have now. So in terms of what the main issue in the case was, it was whether the court has the power to grant injunctions, particularly final injunctions, against newcomers. Now, newcomers are persons who are unknown and unidentified at the date of the grant of the injunction, and who have not yet performed or threatened to perform the acts which the injunction prohibits. Threatened to perform is a reference to the fact that one can get a precautionary injunction. One doesn't need to wait for one's rights to be infringed. One can essentially preempt that by getting a precautionary injunction. So that was the issue, whether can the court grant newcomer injunctions. I'll very, very briefly just touch on the facts, because one, it's relevant for the case, and two, it may be relevant for discussing wider implications later. As Andrew said, this was a gypsy and traveller case. Essentially, a number of local authorities had obtained injunctions over the years from sort of 2015 to 2020. These injunctions were designed to stop gypsies and travellers camping on land without permission. Now, experience has shown, and those of you who work for local authorities will be very well aware of this, experience has shown that when you try and get an injunction against named defendants, named gypsies and travellers, by the time you issue proceedings and they get going, those people have moved off the land and some replacements have moved on who aren't captured by the new proceedings. So in this case, local authorities were granted a number of persons unknown injunctions relating to newcomers. And once they'd been granted, they were then displayed in prominent locations in each of the relevant sites. Now, in the courts below, obviously I'm talking about the Supreme Court, but in the courts below, Mr Justice Nicklin held that although short-term interim newcomer injunctions could be granted, final ones couldn't. The Court of Appeals allowed the appeal and said that final newcomer injunctions can, in fact, be granted. And in terms of what the Supreme Court held, they unanimously upheld the Court of Appeals decision, albeit they did so for significantly different reasons, which I'll come on to. So just to be clear, that the decision of the Supreme Court was that the court does have jurisdiction and power to grant newcomer injunctions, but the court also said that that was subject to certain restrictions and safeguards, which I'll also come on to in due course. Now, in terms of the reasons that the Supreme Court gave for its decision, it said, the Supreme Court said, sort of the baseline position is that the court has jurisdiction to grant newcomer injunctions because its power to grant injunctions is subject to any relevant statutory restriction. That power is unlimited, and that is owing to its equitable origins and its equitable nature. However, although there's an unlimited power subject to any statutory restrictions, that does not mean that the power isn't limited. It is. The court held that the power to grant injunctions are restrained by principles and practice, which have been adopted by the courts over the years. So the question for the Supreme Court was, therefore, whether the court should, as a matter of principle and practice, grant newcomer injunctions, and if so, on what basis and subject to what safeguards. And crucially, the court recognised that those principles and practices can be developed by the courts over time. And in the last 50 years, there have been a number of orders and injunctions that have been developed by the courts, such as searching orders and freezing orders and third-party disclosure orders, which often actually come up in a protester context. So essentially, the law can develop, new injunctions can come into being. So if you can have a search order, a freezing order, and a third-party disclosure order, the next question is obviously, well, why can't you have a newcomer injunction order? And the court held that there is no reason in principle why newcomer injunctions cannot be granted. In fact, the court said that they are a valuable and proportionate remedy in appropriate cases. So there's no reason in principle why newcomer injunctions can't be granted. But in deciding whether to grant one, the court doesn't have a subjective blank check. Essentially, it has to be the exercise of discretion has to be guided by equitable principles, and these principles and circumstances will develop over time. But the Supreme Court did say that newcomer injunctions to prohibit unauthorised encampments by gypsy and travellers, so that's what the court was dealing with in the case of Wolverhampton. What the court said is newcomer injunctions in relation to those unauthorised encampments are only likely to be justified if, and it sets out 5 points, and these are obviously very important points, which the Supreme Court considered. It said that the applicant local authority has to demonstrate that on the full and available evidence, there is a compelling need to protect civil rights or enforce public law that is not adequately met by any other remedies. So the local authority has to show a compelling need to protect its civil rights or enforce public law that can't be met by other remedies. This will involve consideration. I won't go into too much detail, but it will involve the local authority considering other powers that it could use. For example, instead of applying for an injunction, it could make a public space protection order. It could use powers under the Criminal Justice and Public Order Act 1994. And it also has to consider reasonable alternatives to applying for an injunction. So the court said that local authorities should engage in a dialogue with gypsy and traveller communities about trying to give them time and assistance to find alternative or transit sites or more permanent accommodation. So that's the first safeguard or circumstance. The second is that because newcomer injunctions are made without notifying the affected newcomers, procedural safeguards must be built into both the application and the court order. So in terms of procedural safeguards for the application, what the Supreme Court said that in making an application, a local authority should try and advertise that application as widely as possible, so that those likely to be affected by it or representative groups are given a fair opportunity to make representations before any injunction is made. That advertising obviously needs to take place to give a sufficient period of time for people to prepare their responses and to make their response. When you come to court as a local authority seeking a newcomer injunction, the Supreme Court said that applicant local authorities are expected to be in a position to tell the court about what steps they're taken to publicise applications. You also have to make full and complete disclosure of all steps it proposes to take to notify people likely affected by the terms of the order. So when you turn up at court for your newcomer injunction, you have to say, this is what we've done to advertise the application, and this is what we're going to do to try and notify people about the existence of the newcomer injunction and its terms. The third safeguard is, because the interests of gypsies and travellers are not typically represented at the hearings where newcomer injunctions are granted, and many of you will know from experience that's certainly true. Often gypsies and travellers do not turn up and are not represented at these hearings. The applicant local authority will be obliged to comply with a strict duty of disclosure to the court of any matter which a newcomer might raise to oppose the making of the order. So it's a bit like when you turn up for a without notice application for an injunction. It's very much incumbent on you as the applicant to give full disclosure about the kind of arguments that any opponent would make, any facts they'd like to draw to the court's attention. And for newcomer injunctions, that duty of disclosure certainly applies and is very important. In relation, so that's the third safeguard. The fourth safeguard is that newcomer injunctions should be limited so that they do not apply for a disproportionately long period or a disproportionately wide geographical area. That guidance has been in place in various authorities for a long time now, cases like Canada Goose and cases which have followed it. So that's nothing new. But what the court does say is it implies that any newcomer injunction that's granted, it shouldn't be open-ended. Some full injunctions sort of say this will last for a year or two, and some injunctions are just left open-ended. And so in principle, they will apply until there is any further order. What the Supreme Court suggested, or what they sort of implied, was that injunctions, newcomer injunctions, shouldn't be open-ended. They should have a lifespan of no more than a year, subject, of course, to renewal. And they should also include provisions for periodic reviews. And overall, the court expressed doubt as to whether it could ever be justified to grant a gypsy and traveller injunction, which is directed to a person unknown, including newcomers, and extends over the whole borough or for significantly more than 1 year. So that's the court sort of going as far as it can to sort of say, well, we think in principle it would be very difficult to justify such an injunction. And obviously borough-wide injunctions have been going through the courts for some time. So that's the fourth safeguard. The fifth safeguard is that the court must be satisfied on the particular facts of the case, that it's just and convenient that a newcomer injunction is granted. And the final point is that the court explained that newcomer injunctions are a wholly new form of injunction. And therefore, because they're sort of analogous to a contramundum injunction, they are not to be justified according to the Gamble principle. Those of you who are familiar with this area of law will be aware of the Gamble principle. And what the court held is that newcomer injunctions are not to be justified on that basis. They're to be justified on the basis set out by the Supreme Court in its judgment. So that is very much a whistle-stop tour, a nuts and bolts summary of the decision. As I said, reading the judgment is certainly invaluable. And I will now hand back to Andrew.
Thank you very much indeed, Charles. Yes, a very helpful summary there, and I'll come back to some of the broader points we touch on. I'll now call up the two Michaels, not taking the Michael, obviously. Who's starting off? Michael Feeney, you've come on camera, so you're going to now tell us the beginnings of the Kirin.
Yes, thanks, Andrew. I'm going to sort of go through the background and the judgments, and then Michael Fry is going to talk about some of the implications. It has caused some difficulties having Michael Fry and Michael Feeney on the same team, but we've managed to get through it somehow. I'm known by my initials now, anyway. So just briefly on the background of this case, as some of you might remember, in November last year, November 2022, there was a protest action on the M25 by members of Just Stop Oil who climbed up onto gantries on the M25. It got quite a lot of news coverage. It caused huge traffic jams. So the protests were from Monday to Thursday, from the 7th to the 10th of November. On the Friday before, National Highways learned that this was going to happen. And so on the Saturday, the 5th of November, they applied urgently for a precautionary interim injunction, and Michael applied on their behalf. So at that hearing on the 5th of November, Mr. Justice Chamberlain granted an interim injunction. The defendants were described as persons unknown, climbing structures on the M25 without National Highways consent. And there were also alternative service provisions. In summary, the alternative service provisions were publishing the order online, sending it to two Just Stop Oil email addresses, and also notifying the Press Association. It's important to note that at that hearing on the 5th of November last year, two really important bits of evidence was, one, National Highways had got hold of a video in which there was discussion amongst Just Stop Oil members of the training that they'd had to do before participating in the protest action. And there was also a training schedule. And the schedule said that it was mandatory for each person who wanted to participate in this protest to have mandatory climbing training and also a mandatory legal briefing. And so the alternative service provisions made by Mr. Justice Chamberlain were made on the basis that they would be reasonably likely to bring the order to the attention of anyone who was intending to protest. So after the order was granted on the 5th of November, there were protests from the 7th to the 10th of November. And in April, earlier this year, National Highways applied for committal. So this judgment, this hearing for Kirin, was in respect of 14 defendants. There's another 2 committal applications listed next year for another 30-odd defendants as well. And all of the defendants, or if not all, the vast majority, also have criminal trials listed in 2024 and 2025. So at the hearing earlier this year in October, all of the defendants accepted that National Highways had complied with the service provisions, and all of the defendants admitted that they had done acts in breach of the Chamberlain order, that they'd climbed up onto gantries. The only thing that was in dispute from 12 of the defendants was whether they had actual knowledge of the order. They said, we went on the gantries, we accept that you complied with the service provisions, but we had no idea of the order before we went on the gantry. So the first point that was raised by the defendants was a legal point, and the defendants argued as a preliminary legal point that for the claimant to succeed in the committal application, the claimant had to show to the criminal standard that the defendants had actual knowledge of the order. So we spent a day arguing that out in court, and basically Mr. Justice Soole agreed with us, and he agreed that knowledge was relevant only to sanction. It wasn't relevant to whether someone was actually in contempt or not. He also agreed with us that once knowledge was raised as an issue, it was for the defendant to show on the balance of probabilities that they did not have knowledge of the order. the starting point, the presumption, is that once you've complied with the service provisions, the defendant has knowledge of the order. And so the judgment is very useful from that standpoint, in that it goes through the relevant case law and reaches a very firm conclusion. And in short, the simple reason why Mr. Justice Soole reached that conclusion is that there's binding Court of Appeal authority on the point. Kirin and Secretary of State for Transport. The defendants tried to argue that it was obiter, but Mr. Justice Soole rejected that and agreed with us. So after that legal argument on the first day of the hearing, what happened was we got 12 defendants getting up into the witness box, and each of them saying that they had no knowledge of the order. And then Michael cross-examined each of them in turn, and despite his best efforts, it did get slightly repetitive because they all said basically the same thing. They all basically said that they had attended legal briefings, but at these legal briefings, there had been discussion only of the criminal sanctions and not injunctions. They said they were part of group chats or they joined Zoom calls for Just Stop Oil, but that they'd never discussed injunctions on these. They said that before the protest, sort of a couple of days before, they'd gone to safe houses and they'd been told not to bring their mobile phones, so they didn't. And that when they were at the safe house, they didn't check the news, they didn't check the internet, so they had no idea of the order. We said that this evidence wasn't credible, that they didn't know about the order, given the long history of Just Stop Oil with injunctions, given the fact that the protesters were part of a well-run organization that organized climbing training, that organized legal briefings. And we also said it wasn't credible because of how well publicized the order was, and also because the defendants, when giving evidence, couldn't remember some pretty basic details, particularly, for example, the location of safe houses. One defendant said that they could remember it was in England, but that was the extent of how much they remembered where the location was. So we said that the evidence they gave wasn't credible, wasn't believable, and that the court should find that they did have knowledge of the order. So although we won the legal argument, we lost this argument on the evidence. Mr. Justice Soole found that all the defendants were telling the truth. And so the result of that was all the defendants were in contempt of court, but no sanction was imposed for those defendants who didn't have any knowledge of the order. There were 2 defendants who admitted they had knowledge of the order, so they received suspended prison sentences, but the other 12 received no sanction at all. And the final point, briefly, is that for 4 of the defendants, Mr. Justice Soole found that they acquired knowledge while on the gantry, so they didn't know before. They got on the gantry, and then a police officer read out the injunction to them, and at that point they acquired knowledge and remained in breach by remaining upon the structure. But Mr. Justice Soole found for those 4 defendants that no sanction should be imposed either. So the end result was all 14 were found in contempt of court. There were suspended prison sentences for the 2 who admitted knowledge, and for the 12 who'd given live evidence saying that they didn't have any knowledge of the order before going on the gantry, there was no sanction. So that's a brief summary of the case. And now I think Michael's going to give some sort of thoughts on potential implications.
Michael Fry, go ahead.
Thank you. Good afternoon, everyone. Kirin is, in my view, important, and the reason we've tagged it in with this Supreme Court case analysis is that my view is that there's no point in seeking an injunction unless you're prepared to commit in the breach, and it's important, therefore, at the starting position to analyse how you are going to commit people who might potentially be in breach of your injunction. So this case has implications in respect of that. It also, in my view, has far wider implications than protest injunction jurisdiction cases, particularly as regards alternative service. And that's what I really wanted to talk about this afternoon. First, the positive, as Michael Feeney set out, Kirin confirms Marcus Smith J's finding in one of my first committal cases, which was Secretary of State for Transport and Kirin, that knowledge of an injunction where alternative service has been granted becomes a rebuttable presumption if the claimant proves that it's complied with those alternative service provisions. in essence, it confirms that it's for the judge making the injunction order and granting alternative service provisions to consider whether those provisions are reasonably likely to bring the injunction order to the defendant's attention. And that's an important point when it comes to newcomers and persons unknown injunctions, as has been set out in Wolverhampton. The duty on the claimant is full and frank disclosure. You have to point out why the proposed alternative service provisions might not work, which, as we found out in this case in relation to safe houses, can come back and bite you. And so thought needs to be given to that. But on the assumption that the injunction judge agrees with the proposed provisions and those provisions are strictly complied with, and the strictly is important, as if there's a failure of alternative service, even on a technicality, the presumption cannot arise. The burden then shifts to the defendant to show that the alternative service provisions have operated unfairly against them to the civil standard. That's balance of probabilities. And although highly relevant to gypsy and traveller and protest injunctions, it's difficult to see how that principled position cannot apply equally to any circumstance where alternative service provisions have been made. So, as I say, wider implications. That's a positive, but Kirin at the same time is hugely problematic in my view in respect of alternative service provisions generally and in respect of urgent injunctions in particular. And that's because, as Michael Feeney has set out, the judge differentiated between effective service to show breach of an order and actual knowledge in respect of sanction. There was no application in Kirin to vary or discharge the alternative service provisions, one of the safeguards which were built into the injunction order following, trailing the Supreme Court's judgment. So the judge found breach, but the judge found, in my obviously highly biased opinion, that bare assertions of lack of knowledge by defendants in the witness box could meet the required evidential threshold in respect of sanction. In essence, he believed what he was being told from the witness box. And the result was that 6 of the 12 defendants were found to be technically in breach of the injunction, and no sanction was imposed on the basis that they did not have actual knowledge of the injunction. And those protections arise from Ineos and Quadrilla line of cases going forward to today. Perhaps even more problematically, 4 of the defendants were found to be in breach having been told of the injunction while they were engaged in their direct action. That has obvious wider implications for all jurisdictions, but particularly Gypsy and Travellers, for example. Those defendants failed to immediately obey the order, and the judge on the facts chose to impose no sanction. Unfortunately, when we planned this talk, I planned to say more, but I don't want to say much more now because there is potential for an appeal on the basis of the way that the judge reached that finding of no sanction. But as Michael has set out, the facts of Kirin were stark in the sense that the injunction was granted on an urgent basis and alternative service provisions were complied with to slightly more, and depending when the protest took place, but shortly before the direct action protest took place. However, as many of our audience will be aware, particularly in respect of direct action protest and gypsy and traveller injunctions, injunctions are often thought on an urgent basis, sometimes as the actions which are seeking to be prohibited are taking place. And so the approach in Kirin could lead to real problems in enforcement by way of securing sanction the road from your injunction. So I think we can expect lots of contemners in all kinds of fields subject to urgent injunctions not to necessarily argue against breach, but to seek to mitigate or avoid sanction on the basis of a lack of actual knowledge or knowledge only gained in the course of carrying out the prohibited activity. How to fix? Plainly, Kirin's going to need to be distinguished on its facts, but there is a risk that the approach may well be seen as persuasive. My own view is that claimants will need to turbocharge the efforts made to bring injunctions to potential defendants' attention. Wolverhampton says that as well, and properly and comprehensively document that position. The ideal approach will be able to say that this is what we did, and it's frankly impossible for the defendant not to have known. As the Supreme Court in Wolverhampton made clear in respect of the injunction order, it's the substance, not the form of notification, which is going to be the critical point. See 140 of Wolverhampton. That might not be as difficult for some as it would have been for National Highways in the circumstances of Kirin, as most Gypsy and Traveller injunctions, indeed most direct action protest injunctions, concern discrete plots of land or buildings. And my view is that the trustee's stake in the ground on protected land or a building will remain an important point regarding service and now knowledge as well in the breach. I think also that the traditional committal application claimant approach of not saying much about what the potential sanction should be might be coming to an end, as a claimant's going to, I think, need to positively assert, for example, that a set of facts meets the custody threshold. And there's recent authority to confirm that civil committal claimants are not barred from making those kinds of submissions, as they have a private law interest in the outcome of their application. So to round it all up and to bring it back to Wolverhampton, I think that ultimately the Supreme Court's analysis of the injunction stage is going to be equally applicable to committal in the future. You're going to be back to dealing with equitable principles and the relevant safeguards, including fairness, when analysing a committal application in the round. That, for now, is all I think I can say about Kirin. It is a watch this space case, but I hope it might have prompted some questions, particularly when looked at in light of Wolverhampton as well. So I'll pass back to Andrew. The questions and answers boxes, I think, you will have access to, so please do feel free to put in any questions that you have for us.
Yes, thank you, Michael. That certainly raises the question of sanction and proper enforcement. Question whether you just got a rather soft judge who seemed to accept what, when reading the case, seemed to be some fairly implausible explanations that were given by the contemners, or whether it will expand to become a general principle, and indeed what the appeal courts, given your fairly broad hints, might come to say about the reasoning process of the judge. So certainly watch this space. Now I'm going to talk a little bit more about some of the broader implications of these two judgments. Obviously, the first thing to notice is within our broad field of protestor injunctions and Gypsy and Traveller injunctions, there is a very wide read over from the Kirin decision into the processes which will need to be applied for Gypsy and Traveller injunctions. And indeed, the same is true the other way around, as I'm going to go on to talk about a bit more at length, that the provisions about newcomers, and again, just so that we're clear of the phraseology, this is usually identified as categories of persons unknown, people who are not subject to the injunction when it's made, because they haven't undertaken or even threatened to undertake any of the conduct which is sought to be prevented, but they may at some stage bring themselves within the scope of the injunction. And that's really the point that was at issue at in Wolverhampton. Now, looking for the broader implications, the thing that's really significant about the judgment in Wolverhampton, and I have to say, although it is a long read, 77 odd pages, it's not 5 minutes work, but it absolutely, in my view, repays study because of the way in which it gives a very thorough history of the way in which injunctions have come forward and how they've developed over the years. And it's that analysis and the willingness of the court, as we'll deal with in just a moment, to really just not bother about the particular obstacles which had been set in the way in which injunctions are developed, but simply to go back to first principles and say it's an equitable remedy which effectively is adaptable, obviously with appropriate safeguards, but it's adaptable to new circumstances. And it's that clarity of reasoning, and that going back to first principles, which seems to me to be its biggest long-term implication, in that it will open the door, I think, to the ready development of new styles and forms of injunction to deal with new situations. So just touching on how that all comes about, the court at paragraph 14, having sort of stated the basic statutory basis now for the grant of injunctions under the Senior Courts Act, Section 37 of the Senior Courts Act, and delving back into the history of injunctions when there was before the Judicature Act of 1871, the difference between common law and equity and the different routes by which it had to be applied. But the first sort of issues that the court considered was, well, an injunction is simply a remedy, or meant to be a remedy, in an action between two parties, two or more parties, but between identifiable parties to a piece of litigation, and it's a remedy. And the court went through various circumstances in which this principle that you really had to have two identifiable parties to an action before you could grant a remedy in the form of an injunction. And it showed how that had been eaten away at by the concept of representative proceedings, when you might have a single individual claimant who in fact represented a much broader group, that broader group not identified as party to the litigation, but nevertheless injunctions could come forward. Similarly with obscure sort of relationships involving wardship cases, where again it wouldn't necessarily be possible to identify all the parties. But then more significantly, the court looked at the injunction in the case involving the guy Venables who murdered the little kid Bulger, Jamie Bulger, and he was granted an injunction to preserve his anonymity effectively against all the world, in circumstances where it wasn't possible to identify who might have the information and might at some stage leak it. And the court regarded that as a very significant example of how equity would develop an injunction. The second issue was that injunctions as a remedy must, it was thought initially, follow on from there being some substantive cause of action against those whom the injunction was directed at. And again, the Supreme Court looked at how this had been eaten away at with, for example, the development of, as it was then called, a Morava injunction and now a freezing order, whereby an injunction is directed against financial institutions who have no involvement in the case other than the fact that they hold the assets of an individual against whom there is a cause of action. So again, we see the courts having nibbled away at that, well, not nibbled away, having destroyed that principle. Similarly, again, what used to be called Norwich Pharmacal orders, disclosure orders, where an order is made with the force of injunction to a third party who has against whom there is no cause of action. And then again, most significantly, the court said in responding to developments in injunctive proceedings, the internet blocking orders, whereby effectively third-party vendors of products over the internet are restrained by injunction from selling the products of scammers and counterfeiters and so forth. And again, there's no cause of action between the owner of the copyright or the original product and the vendors of these products, but nevertheless, in interests of fairness and the proper administration of justice, and not allowing justice to be frustrated by the fact that people can't be identified, again led to the growth of the internet blocking order. And so again, the court was showing, as building up its logic to this issue of newcomer injunctions, that there had been development of equity, and this is how the natural processes of law would occur. The court then embarked on a very extensive consideration of the basis for newcomer injunctions as had been developed thus far, in the sense that they were accepted as being possible on an interim basis, but not on a final basis. And the court went through the extensive authorities. The Gamble principle that Charles mentioned was really a procedural device to say that, well, when you broke the injunction, you became, by that action of breaking an injunction, even though it couldn't have been addressed to you personally because you hadn't breached it at the time the injunction was made, you couldn't be a party to any litigation. But the moment you broke the injunction, you became a party. That trick almost of logic. And the court said it isn't logically right. And primarily it isn't logically right because it ignores the position of all those who do not break an injunction. They're still bound by the injunction, and the courts, it was said, make injunctions in the expectation that they will be adhered to and not broken. And so the court said the Gamble principle is highly unreliable. It examined the logic in the Canada Goose case and that the distinction that was drawn between interim and final injunctions, newcomer permissible on the current state of the law in interim proceedings, but not so in final injunctions. And again said that was an artificial distinction which had hampered the development of a sensible, equitable remedy, because of in so many cases, in both the Gypsy and Traveller and the protester field, obviously, there is never a final hearing. Often there isn't an attendance by anyone other than the claimant at the return date hearing even. And so the simple act of getting an interim injunction actually does the job that's required for all time. And the distinction between final and interim therefore becomes very unhelpful. And so that's how the court looked at the whole history of injunctions. And the point of going through this in such detail is really to say that there isn't anything in that line of logic that can't be applied in much wider situations. And the court really went on to say, and if you look at para 1, when you do look at the junction, look at para 167 in particular, that sets out the principles really, not just which justified the making on this occasion, almost from a standing start, logically, of the newcomer injunction, but that could equally be applied to new situations as society develops, where new injunctions should be considered to be granted in novel circumstances, without the need for a tortuous logical process to try and find precedent, try and find different ways of doing it. And the points are set out really at 167, the compelling need for the protection of a right in civil law that needs protecting, an appropriate procedural process. And even that the court seems to be quite relaxed about, in the sense that at paragraph 185, it talks about the organic development of principles and procedures, whereby procedures will be imposed in a first order and just on the circumstances of any given case. They're then codified by academic commentary, and eventually they become part of the rules of court. And that process of developing procedural safeguards was seen as very acceptable. And so although there is a requirement for procedural safeguard, that wasn't, again, an obstacle to the development of new and novel injunctions. And that's absolutely applicable, it seems to me, reading this judgment, to all sorts of different situations. Disclosure duty, again, Charles and Michael talked about, and that's obviously very important, but that's going to be the case in any situation where, particularly where one goes without notice. And then appropriate limitations, geographically and temporal. Again, courts never like injunctions to do more than they absolutely need to. And then the broad process of just and convenient. And so I think, leaving a bit of time for questions, the conclusion that one draws about the wider aspects of this case, you've heard from Michael Fry about the wider aspects of the issues of enforcement, sanction in Kirin and the difficulties that that's created. But in terms of the making of the injunctions, the power of what's said in Wolverhampton lies in the way the court was prepared to really tear up that which had gone before, go back to first principles, say newcomer injunctions are necessary in the Gypsy and Traveller context. Equally, there's even direct reference to their utility in the protestor context, and say they're necessary, the safeguards can be put in there, and therefore we're going to bulldoze away all of this tortuous logic that had led to the current situation that came before them, and say this is simply an application of how injunctions develop, and we're going to do this. And that, I think, is going to open the door for many an application for novel and different types of injunctions with a very clear and very substantive, substance-based approach to whether or not a new type of injunction should come forward. So that's where I leave my comments on the wider implications, particularly of Wolverhampton. I think, guys, if we can all come back on screen and on voice, and we'll start to look at some questions.
Can I pick up the first one, Andrew, from Nicola that came in?
Right, you're seeing things I'm not seeing, so
I've got the box open. Can I also make one observation that this was classic Supreme Court litigation in Wolverhampton, that submissions were made on the statutory position, that essentially the Supreme Court went, well, thanks very much, this is what you should have told us, and we're going to tell you what the answer is. So, you know, it was very useful me being there, but the Supreme Court essentially didn't need submissions, and they've got their own jurisdictional basis, so they didn't rely on precedent. They said, we can do this. The other interesting point is they did call into question whether an underlying claim was even needed, as they accepted that very often the injunction is the remedy, and that's something that I'm sure is going to be exploited in the future. But
yes. Well, I mean, that was the whole basis upon which they seem to have analysed the thing from first principles and said, well, you know, well, that's all very helpful, but we're just going to do this because we need it, and it works, and it's just and equitable.
So Nicola has asked, she's got a 3-year injunction on a piece of industrial land where they had a gypsy traveller problem against persons unknown. They're in the 3rd year, expiring January 2025. Is it a dead duck? Being advertised periodically on the website, notices up prominently displayed on the land. If I start, because I've had longer than everyone else to look at it, because I saw the question. As a claimant, you're under a general duty to keep injunctions under review. So I've not seen the injunction order, none of us have. But I think you're going to have to look at what Wolverhampton says about the various duties upon you, about the various procedural safeguards that need to be built into an injunction, and see whether or not your order complies with that. And if it doesn't, it's not a dead duck, but you're under a duty to vary, for example, to include a power of variation for defendants who come into knowledge of the injunction, to make sure that the relevant safeguards, all identified by the court, are in place. And on a review, my view is you essentially need to treat it like a fresh application from the injunction, although the background data of a risk of harm is already there. And if you don't want to read the whole thing, Nicola, 238 of the of Wolverhampton essentially summarises the points that we already knew, that there needs to be a compelling need for protection, the procedural protections are built in, and you've complied with full and frank disclosure, and it's just and convenient. It's exactly the same position, but you're just going to need to review your 3-year order, because that's based on the law as it was rather than the law as it is now clarified.
Yes, it is helpful that the Supreme Court did set out, at least for Gypsy and Traveller cases, some of the appropriate protections that would be needed. They're not, thankfully, novel in the way that some of the things which I imagine might come forward on the basis of the presentation I've given might come forward. And I think Michael is right, and here we tread into the inevitable risk of questions on these things, which is that it represents sort of free legal advice. You know, you will be well advised really to go back to first principles and look at everything again to deal with it. And on that point, Luke Deal has asked whether liaising with police to consider use of their powers is capable of being another remedy. The Supreme Court did make mention that it was necessary for the injunction to be, as it were, as we're familiar with, particularly with planning injunctions, to be the sort of the only thing that will seem to fix the problem. And there was quite an extensive discussion of whether local bylaws could do the job, which seemed to be a bit optimistic. But equally, use of police powers, which of course we know that police powers with respect at least to protesters are greatly expanded, and we've seen use of them extensively in dealing with Just Stop Oil protests in London. But what do people think about the use of police powers?
I think whether it's exploring the alternative remedies, I mean, my own reading of the Supreme Court case is that's more about the local authority exploring the other powers that it has to deal with the problem. But that being said, to err on the side of caution, it would certainly be helpful if you have evidence that you've asked the police and they've come back saying, we don't have the resources to deal with the problem. It can't hurt, frankly, if you're looking to get an injunction, although I'm not sure I'd necessarily say it's a necessary prerequisite, because the Supreme Court was more thinking about alternative remedies that the local authority has, hence the long discussion about bylaws and other statutory provisions. But that's just my initial.
Yeah, I mean, I suppose the question would be, does it matter in whose power is vested the ability to do something about the situation, particularly in a protester context, before a court is going to conclude that on equitable principles an injunction is the only thing that matters? Again, I suppose it's where do you draw the line? The police are fairly obvious. There might be other actors who had appropriate powers who it would be a bit more off the wall to think of them intervening to provide the solution.
There's a bit of a tension as well in the Supreme Court saying you've got to explore all these avenues, when they also say that essentially you've got to think about the purpose of an injunction, and that's to keep people who are going to abide by the injunction not doing the prohibited act. And those people are all sort of caught by it, but they're not defendants to it. And the court assumes that people are going to obey their orders. So if you're going straight to ways of enforcement, and that's the answer to Tobias's question as well about breach of the peace, you're criminalizing people immediately or relying on the criminal law to sort things out. But actually, if you read the judgment of Wolverhampton, what they're saying is an order can of course operate against people who aren't going to breach it. That's the whole point. And it's a way of providing a solution to private law questions that doesn't involve criminalizing people. So I think there's a bit of a tension in the approach there, but I agree with the general point that you need to explore all your avenues and say, look, we thought about this, it doesn't, but it's sufficient to say it doesn't work for this particular reason. We can't keep calling the police out on various sites in our borough to deal with these questions, when all that will happen is they'll move on to the next one. You just end up with that sort of rolling enforcement by police in that context.
Yeah, I mean, one of the options that is given in the Supreme Court is they talk about, I think, PSPOs under the Anti-Social Behaviour Crime and Policing Act. And it's been a while since I looked at those, but there needs to be consultation, and it's not a short process. It's not a summary process. Same with making bylaws, which have to be confirmed. They can't be in contravention with any other legislation. These aren't particularly summary procedures, and so I think, it's certainly something to consider and to explore, without being necessarily something that has to be tried before applying for an injunction.
Good. I mean, we're all fairly experienced in protester injunctions on this panel. What's our general feeling about how the Wolverhampton case is going to affect the way in which protester injunctions are sought and enforced?
I think Michael touched on it already. I think potentially the most significant development beyond what you've already talked about, Andrew, that there might be new types of injunctions, is whether it has to be linked to an underlying claim. It's been left a little bit open in the judgment at the moment, but there's some sort of suggestion, if the Supreme Court is really all about going back to first principles and to stop pretending, essentially to stop pretending that this is a natural evolution from pre-existing, in a sense, for example, national highways, these committal applications, the underlying claim is a claim for trespass. And in a sense, it's sort of pretending, really, because everyone knows that the real remedy is the injunction, and the real remedy isn't the declaration that it's our land, which is technically what you're after in the underlying claim. So I think it would be relatively brave, I think, but I imagine someone relatively soon is probably going to try sort of just applying for an injunction without it being linked to an underlying claim. I wouldn't really recommend doing that at the moment. I think it's still safer to link it to an underlying claim, but I think that might be where we're headed. It's almost a freestanding application. Yeah.
Well, I think also in support of that general notion is the sort of dissing, really, that the Supreme Court gave to the strict division between interim and final. It's clearly a final injunction it's harder to see how that can be made without the support of some sort of underlying cause of action. But if there's a Supreme Court saying, well, it doesn't really matter, particularly in circumstances where the effect of the injunction is likely to be dissipated before a proper hearing could get to court. I mean, Charles and I went through some relatively farcical final hearings against the Insulate Britain and Just Stop Oil protesters to get a final injunction, which actually wasn't a final injunction because, of course, it actually only extends for 5 years. And, you know, I hope we live long enough that 5 years isn't finality. So there's that distinction as well in support of the idea that the whole use of injunctions may become a great deal more flexible and less constrained by sort of points of legal theory, perhaps, and focusing on the substance.
I'm not sure.
Sorry, Michael, go on.
I was going to say, I'm not sure the approach or the result is going to change significantly from injunctions that have been secured in the past year or so. As I think, although the Supreme Court slightly decried the jurisprudential basis of those injunctions, actually, through a roundabout way, they've reached the same conclusions. And the tests that have been applied without notice when applying for an injunction, frankly, meet the tests that are set out in Wolverhampton in a roundabout way, relying on previous Court of Appeal authorities. So you've ended up in the same position, but on a different legal basis. So I don't think recent injunctions are going to, frankly, offend Wolverhampton much. And it's really a vindication of the approach of TfL, HS2, NHL to these wide persons unknown injunctions. I mean, slightly blowing my own trumpet there, I'm afraid, but so sorry about that. But always nice to be vindicated.
I was just going to clarify. I mean, the cause of action aspect is a really interesting part of the judgment, but for local authorities, they can sort of bypass all that because they have their powers under Section 187B of the Town and Country Planning Act, Section 222 of the Local Government Act, Section 130 of the Highways Act. So that sort of gives them a freestanding right to apply for these kind of injunctions. But it will be interesting to see what happens with sort of energy companies, private companies that have had to rely on some sort of quite historic torts on which to bring their claims. So that'll be interesting to see.
Indeed. Good. Well, I think that's a reasonable point, I think, to leave matters. I can assure everybody that when we go to the pub and talk about things, we don't sit around having this kind of discussion. This was very much a work-faced discussion. I hope you found it useful. Thank you to my fellow speakers, Michael Fry, Michael Feeney, Charles Forrest. Again, thank you for your attention. We've put links to the judgments, I think, in the chat box, so you've still got the ability to retrieve them. And as I say, I would finally urge that it really is well worth reading the Wolverhampton judgment in particular. And we'll keep an eye open for what happens on Kirin, see whether we get a more robust position with respect to enforcement. So without further ado, thank you very much, everybody, and see you next time we do one of these. Thank you.
Thank you all. Good afternoon.